Welcome, legal research, writing, and analysis students. The title of this podcast is called Steps in the Court Process, and this is really the sequel to the podcast that you may have seen already entitled Anatomy of a Case. This provides an example so that we can walk through a case together. As you can see, our case is called the Ferocious Dog Bite Caper. You are unwittingly involved in this case because the facts of the case involve Sparty. It's your dog. Sparty bit Fred, the neighbor, as he was walking down the street. Fred had previously thrown a stick at Sparty, which prompted the dog to bite him. Now, the law in our jurisdiction is in the penal code, and it indicates that every person must keep a pet on a leash. If a dog bites a person, the owner is guilty of battery. It is a valid defense if the victim provoked the animal and the defendant then is not guilty. So we're dealing with a battery case here, in that your dog Sparty bit Fred. Now, the case can be filed as either a civil case or as a criminal case, because battery can be both a tort, a civil claim, or a crime, a violation of the penal code. Many of you may already know this, but I've put together here a chart indicating the differences between civil and criminal cases. Essentially, these boil down to, in civil cases, the parties are two individuals. One individual is suing another individual, whereas in a criminal case, the parties are the government, who acts as the plaintiff in the case, who brings this lawsuit, and the accused or the defendant. In a civil case, usually the party bringing the lawsuit seeks monetary reimbursement of some sort, and in a criminal case, the prosecution is seeking punishment, either jail, prison, fines, or probation. The burden of proof is also different. In a civil case, the plaintiff only has to prove his or her case by a preponderance of the evidence, which is slightly more than 50% of preponderance. Whereas in a criminal case, the burden of proof for the prosecution is beyond a reasonable doubt, which is a much higher threshold. There are some other differences. Particularly in a criminal case, there are more protections that are afforded the defendant in a criminal case because the stakes are much higher. A defendant's liberty and freedom is at stake. Now, there are some circumstances in which the same cause of action can lead to both a criminal case and or a civil case. If you think back to, as an example, the O.J. Simpson case, in which the government filed murder charges against O.J. Simpson, and that was a criminal case. After that was concluded, the victims of the families also filed a wrongful death claim, which was a civil case. In our example today, the prosecution filed a case against you, the student, the owner of Sparty. It's a criminal case, not a civil case, and the prosecution is seeking punishment. What does a prosecution have to prove in this case? Well, first, it has to prove that Sparty was a pet. The prosecution must also show that Sparty was not on a leash at the time she bit Fred. In addition, it would have to show that Sparty actually did bite Fred, and that Fred suffered injury or damages as a result of the dog bite. So the prosecution decided to file a battery case against you, the poor law student. So the prosecution filed it in the criminal court, and you entered a not guilty plea. You refused any type of plea bargain that the prosecution wanted to make with you at a pretrial hearing. So then the case moves on to discovery and pretrial motions. We know what all the evidence is in the case, and we know that Fred threw a stick at Sparty, and then Sparty bit him. Now we're moving on to the trial. In your jury trial, evidence is presented to the jury. Now, the evidence can be presented through testimony of witnesses, through physical evidence, expert opinion, or even transcripts if a witness is unavailable. In your particular case, the evidence is presented through the witnesses. So the victim, who is Fred, may testify regarding how he got bit. But there may be other evidence in the trial suggesting that Fred's story is not true. The jury is the final determiner of the facts, and the jury would hear the evidence, hear the testimony of the witnesses, and determine who it thinks is telling the truth. So the facts in your case, according to Fred, is that Sparty is a dog, that it bit him, and that he suffered injuries, and that may be the testimony that comes out on the witness stand. Now, the defense can also put on a case. So, for example, if you want to tell the jury that Fred threw a stick at Sparty and provoked her, then you can put a witness on the stand. You could take the stand, or you could have another witness take the stand. Since ours is a criminal case, however, you don't have to put on any evidence at all. The prosecution must prove its case beyond a reasonable doubt, and you don't have to put on any witnesses or any testimony. In our hypothetical, however, you did decide to take the witness stand, and you told the jury exactly what happened, and that Fred threw a stick at Sparty immediately before Sparty bit him. At the close of your case, then the judge would read the jury instructions or the applicable law to the jury, and then have the jury deliberate by applying the law to the facts and coming up with a verdict. In our case, the judge read the applicable law regarding battery, but refused to give the jury an instruction about provocation. There's an instruction indicating that provocation is a defense to the dog bite statute. After the judge read the jury instructions, then the jury applied the law to the facts of the case and returned a verdict. Unfortunately, the verdict was guilty. The jury found that you were guilty of not having Sparty on a leash, and Sparty bit Fred. So the verdict, you're very upset about the guilty verdict. So you decide to file an appeal with the Michigan Court of Appeals. You allege that the judge committed error when he forgot or refused to read the jury instruction regarding provocation as the defense. The provocation instruction reads like this: to make a sudden threatening gesture to the dog within 5 feet of the dog. Now, there was sufficient evidence that came out because you testified that Fred was within that 5 feet distance and that he threw a stick at Sparty, provoking Sparty to bite him. Thus, there was enough evidence that the judge should have given that jury instruction. If the judge did give the jury instruction, it's substantially certain that that would have affected the outcome of the case. So after you file an appeal, you'll also eventually file an appellate brief stating the reasons why the judge committed error in the court below. You will also get the opportunity to argue your case in an oral argument in front of the appellate court. The appellate bench is comprised of 3 judges who will hear your argument and ask you questions throughout. Let's see how you fared in the Court of Appeals. You argued your case in front of the panel, and the court handed down the opinion. We find that the trial court committed reversible error when it failed to give the appropriate jury instruction relating to provocation. Since provocation was an appropriate defense given the facts, we cannot say that the jury would have arrived at the same verdict if the judge had so properly instructed. We hereby reverse the defendant's conviction and remand this case for further proceedings. You won, and that concludes another exciting victory in the life of the poor law student.